Welcome to the Compliance and Amendments Committee of the Sunshine Ordinance Task Force. We are reading a statement on meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave.
Call the next item. Item number
Yes,
one.
please.
Item number one, call to order, roll call, and agenda changes. Member Wolf?
Here.
Member Wolf here. Member Hinsey, not present. Chair LaHood?
Here.
Chair LaHood, we have a quorum. We do have agenda changes. I received a letter of withdrawal for item 5, file number 19146, complaint filed by Anonymous against City Librarian Michael Lambert in the Public Library for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and or complete manner. So we will not hear that. I also received a phone call from an administrative assistant at the University of California Chancellor's Office who said they will not be making an appearance for item number 4, file number 19138.
Thank you. Next item, please.
Next item, item number 2, approval of the January 28, 2020 Compliance and Amendments Committee meeting minutes. Do we have any changes?
I move to approve the minutes.
Okay, we have a motion to approve by acclamation.
Okay.
I got to call public comment.
Oh, public comment on the minutes. Seeing no public comment, we'll take the minutes by acclamation.
By acclamation, okay. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Do we have any of the members of the public wishing to speak on items not on today's agenda? Seeing no members of the public wishing to speak, next item, please.
Item number 4, file number 19138, complaint filed by Stephen Malloy against the University of California Regents of the University of California for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner.
Is the petitioner here? Yes. Okay, and we know that the respondent is not appearing. So if the petitioner would like to come forward, just to be clear, what we're doing here today is determining jurisdiction and possibly considering if all of the documents are complete. We will not be having a full hearing.
Just want to reiterate the reason that the University of California will not make an appearance is because they feel they do not fall within the guidelines of the Sunshine Ordinance. Is it working? It was a second ago. Bring it down.
There we go. It's in
There
focus.
we go. Okay, great.
All right. Thank you. Good to see everybody again. I have, so 5 minutes, right? Okay, thank you.
Clock's running.
I just wanted to put this up real quick. You all already have this going back to when I presented it to Ms. Leger. But basically, you see, this is the contract that I worked under at the university. It is the contract between the city and the state. Basically, that's it. It's a standard agreement. As part of that standard agreement, one of the clauses is that the Sunshine Ordinance is indeed any other record of communication between city and persons that fall underneath the ordinance shall be open to inspection immediately after the contract has been awarded. And the contract was awarded July 1st of 2018. The university knows this. I don't need to, explain that. I do want to add that if you go to item number 53, the university also knows that per the contract, the parties shall comply with all applicable laws in the performance of the agreement. So they understand that. that. The university also understands that in Appendix G of the contract, I think I might need to do a little something. There it is. There is the intergovernment agreement, which is that all restrictions or limitations or conditions passed or enacted by Congress or statute that may affect the contract have to be provided. That is an important issue because I am a protected veteran, and as such, the university is a federal contractor, and they have to comply with all equal benefits and privileges that I am to be awarded. And so underneath his contract, one of the benefits and privileges that I am to be awarded, including under city, state, and federal jurisdiction, is a receipt of written records. That is important because I just want to show you quickly, you all already have this, but for example, when the university responded to me, I had provided them all of the people that, and by their different business groups, fell underneath the Sunshine Ordinance to produce written records, because all of these people have produced written records. So whether it was the Executive Provost's Office, or Legal Affairs, or Labor and Employee Relations, or HR, or the Office of Personnel and Diversity, Title IX, Chancellor's Academic Affairs, they have a whole host of records. Many of these records are actually between city and state because of the close ties of the contract. So they're not exclusively even university records. They're a mix, just like my records are. My records are a mix of both university and city. And so, yes, the records are there. I'm just simply asking them to release them, and they have not complied with the contract. Thanks.
Thank you.
Any questions? If you have any questions of me.
Well, we'll get to that.
So we don't have,
Oh, we don't
there was
have
no
the-
respondent here.
Okay,
So,
great. Just want to ask our administrator, did the respondent make any kind of statement regarding?
No, there was no statement. When I got the phone call, it was from an administrative assistant in the chancellor's office who said that, well, first he couldn't find the documents that they had submitted. When I pointed out where they were, he said, great, they're there. That is what they are supporting their argument with, and therefore they will not make a personal appearance today.
Okay,
Explained it's very important and to their benefit to do so. I said, just try to send someone, and that person was not ready to be compliant with that.
did they submit a response?
they did.
They did.
What
I
page
believe
is
it
that?
starts at page 172.
Yeah, got it. Response. Right. Just want to go back to our legal counsel's memorandum for a second. Okay, Mr. Malloy, if you come up, please. So what's your contention that the additional responsive documents that exist have not been produced?
When you say contention,
I mean, you have some argument that they still have some documents that are supposed to be provided to you?
right, they haven't produced any documents. What everyone has done,
Okay.
they included is they send me my email. And of course, the point is to go in and, like those names I was showing you by the department, pull the written record. And just like everybody else, whether it's DPH or DA or, city attorney, they don't want to do that because they want to keep that information, from my standpoint, secret and not disclose. And of course, with my case, the issue is that the disclosure will probably indicate some liability and misconduct on their part, but that does not give them the right to hold the record in secret. And that's what they're doing. For example, they instituted the same clause with me with my personnel records, where they said, we're the regents, we don't have to give you anything more. That is not true. Under state law or applicable law, they are still responsible to comply. And so I have a state hearing with the industrial committee where they're going to tell them, no, you have to give him all of his personnel record. You cannot cite your constitutional immunity and then pick and choose which records you do or don't give him out of his personnel file.
Which committee was that?
Excuse me?
Who?
That's the State Department of Industrial Relations. They handle all complaints when the respondent does not provide you, in my case, my full personnel record.
Okay.
Because they cited the same constitutional immunity. And again, under CIPRA or CPRA, you have to comply. And so it's the same with this contract. It's the same with every jurisdiction I deal with them, that they want to cite the immunity, but they still made a commitment to applicable law and they have to follow through. Immunity is a separate issue related to how they can manage administrative proceedings for faculty who engage in misconduct. That does not spill over to a criminal or a civil court unless there was an actual statutory violation. Otherwise, the university itself, it's only one of only 3 states in the country that allows them to maintain jurisdiction internally. And so that's a normal response.
Well, but they still have to follow the California Public Records Act, nonetheless.
True, they do, but they have refused, and as you saw, that was part of my thing, is you have all of these people who've generated written records, and you are attempting to say that none of them have any records, or we have other statutes that we want to put forward, none of which are at issue, and all of which require you to comply, as well as my work contract requires you to comply.
In the microphone, please. I'm sorry.
Yeah, as well as my work contract, requires you to comply.
Okay, and so
Thanks.
You had pointed out and included in the record the actual contract.
Correct.
Okay. This is a contract for what?
That's the contract between the city and Department of Public Health, because UCSF serves as the case manager for all mental health of city DPH clients. So in my job, I worked for the university, but I did the case management and patient navigator.
You brought up 3 different entities. Who has the contract? Does it UC have the contract?
Well, the contract is between the university and the city.
Okay, but it's through DPH.
Yes.
Okay.
That particular one centers on my work group. There are other contracts for all of the different other divisions, but mine was Department of Psychiatry, Department of Public Health.
Okay. And, okay. And have they provided you with any documents?
No. All they've done is return to me what I sent to them, and they haven't produced anything similar to that email I showed you and you have in the record where I indicate, hey, this department, these people, I'm pretty sure they communicated. This department, these people, they know that.
So I'm looking on page 28, State of California Public Employment Relations Board complaint. Okay, was that settled?
No, that is the prima facie case that was established with the emails from Veronica Vane when she made a mistake and the city attorney didn't get to her in time, and she released me only 9 emails of all of the available emails. I have tons more. And when she made the mistake, it demonstrated that the city had breached the contract and engaged in retaliation against me. And so that is PERB under collective bargaining. The council has demonstrated that the university violated the law, Higher Education Act, and we go to a preliminary settlement conference this Friday.
Okay, I'm just, one of the things I'm concerned about is if this is being heard in other procedural bodies and the particulars are similar than what you're
Right.
bringing here.
No, they're not. Separate lanes, separate
Okay,
jurisdiction.
did any other government body order them to produce these documents?
No, no one else has focused on the document piece because no one else is involved in that as of yet.
Okay.
And no court at the moment has indicated anything by injunction or otherwise, no cases at that point. So this is the only jurisdiction and the only case that I have at this moment on this subject. PERB is related to collective bargaining and the contract, the union contract. It's not related to the records piece. It was just whether or not they retaliated against me, and the answer is pretty obvious.
Okay.
Yes, they did.
Okay. Yeah, so I don't know. I was a little confused because looking at that, I wasn't sure how that was applicable.
Yeah, I wanted to let you know that the preponderance of evidence so far, which would indicate why they did not come today, is that they are guilty because in PERB, similar to how you all do the initial step before it goes to the task force, in PERB, the attorney group there does not allow you to have any consideration until they approve that you actually have a case that demonstrates prima facie. And so when they do that, they're basically saying, we're going to back you up and we're going to come forward and support you because they did make a violation. So I just wanted you to know that the university has an established link to guilt already in this subject matter, which would indicate why they tend to not want to respond, not talk, but that's on them. They're big boys and girls, they know. But you're the only jurisdiction on this subject.
Okay.
And you know, in your literature on your website, I see where it talks about both city and state agree to work on these types of issues to help support open government. There is something on the ordinance about that.
The ordinance says that the Sunshine Ordinance Task Force can find violation of CPRA or the Brown Act and any of the enhancements that the Sunshine Ordinance provides. Both those laws allow for, I think it's both, at least the CPRA provides for local agencies to provide enhancements
Right.
for added transparency, efficiency, and expediency.
Right.
So that's why, our turnaround time is 10 days here, not 14 days. And so that's the enhancement. A lot of people get that mixed up.
Right.
But, yeah. The question, I guess the question is before us, just so we can advise if we choose to find this in jurisdiction, is just the standing of the contract, that it is in fact a contract that would be applicable under either the Sunshine Ordinance or what's called 12L. 12L is the Sunshine Ordinance for nonprofit organizations. Basically, that's when a department or agency contracts with a nonprofit to provide a service. Usually those are, kind of like they receive a grant, and then they provide a service to the public.
Right.
Okay, not necessarily doing contract work for the city, but doing contract work on behalf of the city to the general public, kind of like Meals on Wheels kind of thing, right? I think that is really has to be our first litmus test here, is to determine, because they're claiming that because they are this entitlement that operates independently of all branches of government, pretty much, that these laws aren't applicable to them except for the CPRA. If there's a violation of the CPRA, if the task force finds a violation that there's the CPRA, it still is binding, but it first has to be determined whether the university is actually a contractor or whether it is like just operating within the city, like the school district or city college or something like that.
It is a contractor. And the reason that I showed the Appendix G portion on the intergovernmental restrictions is because, as they know, that immunity clause has no weight because they agree to comply across the two state and federal sectors.
Can you put your document back up there? I mean, it's not marked. It doesn't have any markings in our packet. But I noticed that you pointed the areas that you pointed out, just so we're clear, and that when we give our brief, the committee's brief before, if it goes to the task force, then we can make it clear. If you can go slow because you went pretty quickly, I'd appreciate it.
So the first part,
Into the microphone.
as you see, is
You can point to it on the overhead. Just put your finger down there. There you go.
is the July 1st through, just the timing on the date, okay? And that it is between the regents on behalf of San Francisco campus, all affiliations basically is what that means, and the city, all right?
Okay.
And so that establishes it as a contract. It's not in the category that you're talking about. Because I actually had gone over and met with Regina Chan in contracts, and we talked about that kind of stuff.
Okay.
When you get to section 40 in the contract, it actually specifically deals with the ordinance.
Okay. That's what I was wanting
Right.
to get to here. Okay. Got it.
Right, and the only restriction is about, private disclosures, net worth, things like that. Otherwise, they agree. Now, the university is great about striking anything in a contract that they don't agree with, including in this one, right? There's a number of areas that they struck. They didn't strike that.
Okay.
And
53.
53, just that indeed all parties agree to comply with all applicable law.
Okay. All right. That's enough. Okay. Thanks. Okay.
Do you have a?
Yeah. So I'll just say that I think it's compelling. I think that the first test is the against the argument that by the respondent, however it came, that they, pretty much operate outside of the city's laws. And I would say in the course of their regular business of doing what they do in the city, whether it's at the hospital or providing classes or what have you, I would agree with them on this. But in this particular case, it's clear that the contract makes them under the jurisdiction of the city and county. That's the first part. As far as determining whether the petitioner has any claims with regards to that, that's something for the task force to deliberate and not here. What we're just trying to do is determine whether it actually we can hear this or not. But I think it's pretty clear, and I think where is it?
Well, and you brought up 12L, and 12L doesn't suddenly turn another entity into a department, but it means that certain information needs to be disclosed.
Yeah, I mean, if it is 12L, now we're not here to
We're
determine
not here to determine that. Yeah.
If it is 12L, I mean, let's put it this way, if they received the grant and they were providing services on behalf of the city through that grant, or they were contracted to provide certain, like a food kitchen or something like that, then it would be 12L.
Right.
Okay, we've had those cases like with regards to like I think it was the Bayview Opera House.
Right.
Right? So they received some money to be able to operate that, and so they're a 12L operation. It could be a low-income housing provider receives a loan from the city. That would be still a contract. That would be a 12L. So under that, just for everybody's edification, you can't ask the nonprofit directly for the information. You have to ask the contractor for the information. The contractor will usually have some information, and then if you want additional information, they're not required to provide it. They may provide it.
Right. It doesn't mean that suddenly you have the same level of visibility that you would for a city department.
Right. So here it's different because this is a contract for providing services under a department. For otherwise the department would be providing for itself, in its own purpose. So it's more inclusive. It's the kind of thing where if they were, it's like for, let's say like landscaping, for the landscaping city hall, or for, cleaning the building, cleaning service, things like that. That's where those contracts come in for procurement and things like that. So it's clear, though, from the language of just in the opening preamble, that they're referring to them as a contractor, which is very specific, especially to the ordinance, and the fact that the sunshine statement was in there. This had to have been looked at by the city attorney. It obviously went through the Office of Contract Administration. It was, approved and whatnot. I don't see, how they could now say that they were, So I think this is applicable, and I think we move forward. As far as the other particulars, the question is. That's why I asked Mr. Malloy if he received any documents, and he received some, but not all that he was expecting. Let me ask you again, Mr. Malloy, do you believe that there are other documents?
Yes, I do. There. All of those people that I cited in each of those departments have touched and have created records. Ziggy, come here. Get over here.
I have a dog back here, so please. Thank you.
So all of them have not produced records, but do have records. And so there are many records.
How do you know that the records exist?
In many cases, I would have communicated with those people, or within the framework of the university, those are the people that subject matter has to route through, because UCSF's like the military. So in terms of personnel, it has to go through those people. In terms of records, it has to go through the provost and academic affairs office. So it routed that way. I know the route of how the correspondence goes.
And which records, and forgive me, which records exactly are you looking to acquire?
Those written records concerning Stephen Malloy, because I know each of those departments had meetings, had discussions, created drafts, memorandum. I don't know specifics. That's what I'm trying to get to the bottom of.
I am trying to. I also want to make sure. I've combed this packet. I can't seem to find your original request. To them? To them.
I have it.
Yeah, but is it in the record here?
I think so. Yeah, because I gave the full email thread.
Yeah, but okay, it's in the email thread? Okay.
Right. You should have one for UCSF, which is primarily Brenda
Yeah.
Gee,
What page?
and then
Isn't
one
this-
for Dan Scannell.
What page?
Hold on. I'm on-
64?
You know what? Maybe I'm on the right thing.
I see. Thank you for the update, Mr. Scannell.
Okay, and then I
And then
think
after that, I don't see anything else. That's the first email in the thread that starts on page 65, and then going to page 64.
You can look in the notebook. Do you have the notebook?
Hmm?
The
So
blue
it starts
notebook?
on November 19th, 2019. Because otherwise, we have really no way of knowing what you're asking for.
Oh, actually,
It's taking me just a second. Yes, you were saying?
at the bottom of page 50, and I don't know if this is the original, but you attached this as part of another letter. So
Page 50?
at the bottom of page 50. Is it on November 8th? Was that the original request?
Almost there. Yes. So that one is to UCSF. And so you see where I'm contesting her on different points where she's trying to deny me under CPRA. And then you see on the page 51, I list for her, to aid you, communications and records may be found with the following UCSF departments and personnel concerning Stephen Malloy. And so I list them. Now, that's just my intuition because of how I know how records track in the university. If you were to do a data search and you were with the server, computer people, I'm sure they'd find a lot more. I was just trying to guide them, which I didn't have to do, and they know how to do that.
Yeah, that's fine. What we're trying to ascertain is what your original request was and what it was for. Not the arguments because they didn't provide them.
It's for that. So you see at the top on page 51, I say to aid you, communications and records may be found with the following UCSF departments and personnel concerning Stephen Malloy. So written records for me based on those areas.
Okay.
And then if you go to page 60, you see where I have done the same thing for Dan Scannell.
Yes.
Wait. Yeah, I think
It's just that what's difficult about the way this is written is you're responding to the original request. And that's how we usually operate based upon starting at the beginning of the whole.
So on page 62,
Okay.
at the top, you see on Tuesday, November 5th,
Got it. Okay.
I am requesting a global.
Got it. Okay. Thank you.
And
That's what I was-
And then they requested
Right.
some modification.
Right. And then for Ms. Gee, her original request would have been on she has a November 5th one as well. I don't know where that is because I emailed them both on the same day.
That's okay. We just need to
Okay.
provide reference
Right.
to the.
They both got the same email, and then in both cases, I did what you saw me put up on the board and also on page 61, where I listed for them, hey, these are the people, go here, look here. You should be able to pull from there.
Okay. So I just want to note for the record and for the minutes that the original request begins on page 62. That way everybody has a place to start with this and can follow it.
And, to your point, Mr. Wolf, you can see in there where each time she would say, well, CIPRA says that, I can't do it because of this, I would combat that argument. And the last one was, well, there's an investigation going on. And the university closed the investigation April 26 of last year, and just again attempted that's been an ongoing investigation since October 17th of 2018. So it always is some, delay, some reason that holds no weight. And all of those people aren't even involved in those things, right? So she's not even making the attempt to pull a record to even attempt to see if it needs to be redacted, or to attempt to see if it is under some exclusion or not. She's just, I'm not going to pull any record. And she doesn't get to do that. She's the custodian. She knows she knows how to do that.
On page 63, you note, I want to see the records. Please call or email me when the records are ready for viewing. Do
Right.
not make copies on my behalf. I will review the records first and indicate those that I wish to copy. Did they provide you an opportunity to view them in camera?
No, and that's been the case, as I indicated in the last email I think I sent you the other night, that no department, I've asked everybody, let me come in and sit and see first,
Right.
so that you don't waste your time, I don't
Right.
waste mine,
Okay.
and everybody just
Okay.
won't do it.
Okay. All right. That's all I have.
Okay. Do we have a motion?
Yeah, I'll move to find jurisdiction and find that the UCSF is an official contractor with the city based upon the contract that was presented, and the applicable paragraphs regarding the requirements under the Sunshine Ordinance and the applicability of the laws that apply to the contract. And as far as the and that the information is public, okay, and then they can come if there's anything they want to cite as far as redactions or exemptions or anything, they could do that at the hearing.
Okay.
And that we're forwarding to the task
We're
force.
forwarding a task force, yeah.
Okay. I guess I have to second the motion, and
Right.
then we call for public comment. Seeing no public comment, please call the vote.
Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes. It'll go to the task force.
Next item, please.
Item number 6, file number 19114, complaint filed by Shane Anderes against Tyler Vu and the Public Defender's Office for allegedly violating Administrative Code Section 6724, 25, 26, 27, and 29 by failing to respond to an immediate disclosure request in a timely and or complete manner. This matter was heard on February 5th before the task force and was referred back to the Compliance and Amendments Committee to determine if existing records are public.
Okay, and it looks like all parties are here. Again, this is not a full task force hearing. We are only here to determine if existing records are public.
Right. I think it's worthwhile to read what the action of the task force was. I'm happy to do that.
Okay, please.
So I'm reading from the minutes of February 5th, 2020, of the Sunshine Ordinance Task Force. And this is the action for file number 19114. It was moved by Vice Chair Josh Wolf, second by Member Robin Martin. Moved to find that Tyler Vu in the Public Defender's Office violated Administrative Code Section 6221B by failing to respond to a request for public records in a timely manner. In addition, it was moved that the matter be referred to the Compliance and Amendments Committee to determine if the existing records that were withheld are public or private, and requested the respondent to provide additional information and citations to justify their position that records assembled and retained for the purpose of assisting in the defense of existing and future clients is, quote, a private function and not relating to the conduct of the public's business, unquote, and are therefore not public records subject to disclosure. So that's where we're going to pick up from here. I think then it's appropriate to have the respondent present, since the burden is on the respondent.
Good afternoon.
Fine.
Good to
Hang
see
on.
everybody. Oh,
Talking to the microphone. You can begin.
good afternoon. It's good to see you all again. So I think in terms of addressing the first issue of this of the citation, as we stated on page number 300 of the record, the respondent in my office relied upon Coronado versus Police Officers Association versus Carroll. That's cited at 106 Calap 4th, 1001, at page 1009, for the position that the core function of the Public Defender's Office is not public in nature, but it is to represent private clients, and the records that are being asked of, as it pertains to items numbers 3 through 15, are used and were acquired and maintained for the purposes of defending current and future clients. And so therefore, they are not public in nature. Now, part of the request is also does contain some public items, and for those items, we have told the petitioner that we do not have records for. So, for instance, we don't have any records of, for instance, misappropriation of funds or resources or benefits. We don't have any records of unlawful discrimination, abuse of authority, or violence on any of the people who are being asked of. All of the records that we have, those records that if we did have, we would release, but they do not exist. The only records that we do have are records that are used to basically defend private individuals.
So for those other items, I'm probably going to bounce around for a few items here based upon your testimony. For the items that you just noted that that are unresponsive, the items that you don't have.
The items that they don't exist.
So for the items that don't exist, do you know where you might assist the requester to find those records?
I wouldn't know where to look because all I know is that there is no record of misappropriation of public funds.
It's okay. I'm just asking for the pure function that the ordinance has a requirement that if the custodian does not have the documents, that they must assist the requester on where they might possibly be able to find them. And if you don't know, you don't know.
If I were trying to be helpful, what I would say is, you could check with the state bar. The state bar does hold complaints against lawyers.
Okay.
In general, it's a licensing agency,
Mm-hmm.
so they would have information as well.
Okay. All right. So at this point, you're I guess what I guess the hard part for this is understanding the relationship of the public defender to city government. Okay, I think that is where some of the crux of this is, because the taxpayers of the city and county of San Francisco pays and funds the Department of the Public Defender. There is some public entity connection there. There is some requirement to follow the local laws, or else the Sunshine Ordinance would have said that it's exempt, okay, for maybe the particular arguments that you're putting forward. But it doesn't. It's silent on that, and so is the CPRA, except where there are exemptions that are available, that are applicable. Now, I do understand the Coronado case. The question is what our job here now is to try and figure out which documents are or not, and to understand whether the reasons for that are, how are they applicable in its specific nature. So.
Well, I mean, one of the big challenges here seems to be that we have no in-camera privilege. So we
Right.
couldn't even say, well, show us the documents that you say are attorney-client privilege. We can't ask you to show us so that we could make a determination. And I think that's one of the challenges.
I mean,
the petitioner is stating that the use of the Coronado case is misplaced, and that the requests that he's making does not contain a mixture of client documents and publicly available information. That such disclosure would undermine the public defender's ability to perform its public function. That's the requester's argument.
sure, and I think that's something that at the heart of what the court reached at in Coronado is the question of, well, to what extent is a public defender's office a public agency, and to what extent is it a private agency? And the court clearly cited on the private side, but it did not say that the office was somehow outside of the umbrella of CPRA.
But did Coronado, did the judge in Coronado, was it judge or appellate?
It's an appellate decision.
Appellate decision. So did the justices, did they have the opportunity to see the documents in camera so that they could determine which ones were private and which ones were public?
Well, in the decision, they described the type of documents that they considered private. So in the Coronado case, the court in its decision, I can read from it if you like.
I just want to review because it's been a while.
Sure. So, for instance, in the Coronado case, what the court described was basically the public defender scanning items in the client's paper files, and then the public defender gathering data from public sources, sharing data that it had found through the investigation process, data that it had collected from representing prior clients, and it assembled all of this. And what the court said was that the act of doing that, the act of assembling, was a private function of the public defender's office. Now, to answer Chair Wolf's issue, which is to what extent does the public defender have a public role? And what the court said in the Coronado was that, so even though the materials within the database itself was protected and private, what the court said was that the decision to start the database, how much the database costs to maintain, those are all items that are not private, that are in fact public, and that therefore would be disclosable. So the court kind of puts an example and kind of lays out on the left side what is private, and on the right side what is public in the Coronado sort of test case, or in the Coronado example. And in applying Coronado and trying to respond to petitioner's request, we did the exact same thing. So we did not just outright say, there's nothing here for you, we're private, leave us alone. We did disclose items that petitioner asked that were public. So, for instance, petitioner asked for articles for our office meetings on the Heather Knight article, and that was in item number 1. And so we did provide petitioner with agendas where Heather Knight was discussed. Obviously, that's public. That doesn't pertain to a client, and so therefore we actually comply with Coronado. But to the extent that the rest of the items resided in client files, and they were compiled for the purpose of representing future clients, Coronado by law tells us that that's private, and that we would be doing a disservice to our future clients if we were forced to hand it over. So to answer,
are we talking about the same exact type of records as what was presented or argued about in Coronado?
well, actually, even more restrictive, because to the extent that these records exist, and I want to give you a sense of what my
But
office
we
is
don't
like.
know what the records are.
Well, let me give you a sense of
Okay.
what records we would have. To the extent that these records exist, we have two kinds of records. We have personnel files, which are stored by HR, and we have client files. Those are the record world for the Public Defender's Office, and I'm willing to say that's also the record world of the DA's office, is that they have client files, or they have case files, and they have personnel files. Now, in the case of personnel files, we did look for items that would pertain to public interest, public business, and we did not find any items, so therefore we had nothing to turn over. In the world of client files, that's all that's all there is that the materials reside in actual client files, and they pertain to representing clients. Now, just to give you a sense of how expansive Coronado is that what Coronado said was that not only are the items
Into the microphone.
within the client files protected, but what Coronado says is that even items obtained publicly. So in the Coronado Public Defender's case, that Public Defender's Office obtained both private client file materials and publicly sourced materials. And what the court in Coronado said was that those things were private in nature. Those things, yes.
I have a question. Okay, so if there were files pertaining to misconduct, why would those not exist in HR?
Files pertaining to misconduct?
Yeah, so there's questions here about all documents pertaining to alleged misconduct.
Yes.
So why would those not
They
be,
would be in HR.
They would be in HR.
But we just don't have any. We don't have any in the area. We don't have any misconduct files in HR, in the personnel files.
You don't have any misconduct because no misconduct ever happens, or because it's not kept there?
Because we don't. They're just, when we looked into the HR files, there's nothing there. So I have nothing.
I guess for anybody, no, there are no misconduct files in HR, or no misconduct files for these people.
For
in
these
HR.
people, because that's where we looked. Because we were trying to respond to whether or not there were sort of public misconduct by our staff. Things like, so for instance, violence, abuse of authority, unlawful discrimination based on status, misappropriation of funds, benefits, or resources, and there were nothing of that category. Now, that's the HR file.
If they don't exist in HR, or I guess I'm a little confused, because wouldn't misconduct files be at some point attached to personnel files in HR?
You would think so.
And otherwise, I don't understand why they would end up in client files and not at the very least be replicated somewhere else. Why would they be stored within client files?
Because the world of the I think I discussed this last time with you as well, which is the world of the Public Defender's Office and the DA's office, that both sides are constantly accusing each other of doing a wrongdoing in court. Both sides, this attorney, that left attorney will say, you're doing this wrong, I'm doing that wrong, and they're just it's the nature of the work is that you have two sides are opposing each other and they're fighting and they're it's not an agreeable situation. And so if there were misconduct that's alleged during the course of representing clients, they never rise to the level that would go into an HR file. Unless, of course, someone contacted and said, your attorney is doing something that sort of is about violence or about abuse of authority, right? That's the world in which the data exists. So in asking for items like Concerns 5, 6, 7, 8, and 9, all documents pertaining to alleged misconduct, it would be sort of an impossible task to figure out what that means, because the course of representing clients, the files are just it would be impossible to find those items.
I mean, that's a little kind of a vague answer. I don't know why would it be not possible? I mean, what is about the records in the file would make it difficult to determine if they were relating to misconduct or not?
Because we represent clients in criminal cases, and the files are stored, in a huge room, files deep, with just court numbers and client names.
Are you claiming that it's voluminous or that it's a hardship?
It's not that. It's just that I could look at that file and there would be no notes about it isn't something that we, like a DA saying that a public defender has done some misconduct is not going to be recorded down in a way that you can actually find the record. There isn't a methodical way to fulfill this request. And even if there were, what we're saying though is that this is the misconduct alleged is in the course of representing clients. It is something that the Coronado Court has already said is like sort of you don't want your public defender to be disadvantaged in a way that your private attorney would not be disadvantaged with this request. But
the question is how are these particular records create a disadvantage? That's hard for us to determine without you being specific about that.
The idea that,
how do we know what would be applicable or not applicable with regards to what the intent of Coronado, the appeal in Coronado, is trying to notate? I mean, I do understand in Coronado, the appellate court denied the appeal on the grounds that the database is not a public record. Okay, so I get that. Okay, and then it says even if it is, it would be exempt from disclosure under the CPRA's catch-all exemption of Section 6255 because the public interest in non-disclosure clearly outweighs the public interest in disclosure. It's kind of the reverse of what CPRA its intent is. Usually CPRA works the other way around. It's usually in favor of disclosure than non-disclosure. So I find, having read this a few times, I find that interesting. But the question is whether the question is if the file is not in the database and it's in some file cabinet, then it's not in a database. Okay, to me, that's what was interesting about reading about this, because the public defender was claiming, the San Diego County public defender was claiming that the records that were being asked for were contained in their electronic database. The question here is, are the records that Mr. Andres is requesting, are they contained in the database? Because that is the central the central point of the matter in the Coronado case. It wasn't of whether there was a paper file. It wasn't asking about that. It was asking about what was in a database, an electronic database. And you're correct. Everything about the database, where they bought it, what kind it is, how it gets, configured, all that kind of stuff, yeah, that's all public based upon the procurement area. But now we're talking about the information that's stored in it. So the question here is are you claiming that the information that's in the database is not disclosable, or are you claiming that other than what's in everything else not in the database is not disclosable?
I think what I'm saying is that whether there's a database or not isn't relevant to the logic behind the Coronado case, which is that the public defender's office, in the course of its role, which is to represent private clients, even though it is a state agency, is entitled, and this is from the court's word, to maintain a level of independence equivalent to a private attorney.
Yeah, I get that point, but the core of Coronado, I'm reading right from it. The association, which is the Police Officers Association, discovered the existence of the database from a newspaper article. It sought to inspect the database under the Act. I don't think the petitioner here, that's not the case he presented. He didn't present to inspect the database. He just asked for certain records that you might be custodian of. That's what he's asking for.
But the thing is that the way that we would find out if there's any allegation of misconduct committed by public defenders is to comb through client files. That is the only way to get his request. Is to figure out, to ask every single attorney, have you had an allegation of misconduct done against you? Now, what the Coronado court said was that you have to try and treat public defenders like private attorneys, to the extent that you would want a private attorney subjected to the same kind of oversight over their private function. And if you only make public defenders do that, then you are putting a public defender's client at a disadvantage to someone who has money, who can hire a private attorney, whose attorney wouldn't have to do that. And that's the core.
I understand your point as far as the purpose and the ability of the public defender to do its job, and in protecting the client. I get that part. But the use of the question, the problem I'm having is that I'm not necessarily seeing in. I'm not. It's hard. I can't. It's not a one for one. Okay, because that is not. Coronado revolves itself around the database. It doesn't revolve itself around files that are in a file cabinet.
Because it's.
And that's what the core of Coronado was with regards to. Now I understand your point.
Because no one would go there.
Just look at the.
No one would go there. No one would ask to see the files of clients in the public defender's office. It's protected by attorney-client privilege. Right. No one would. The reason why Coronado doesn't go into the question of files is because the idea that anybody can do a public records request and have the public defenders comb through its client files, it would diminish our ability to represent poor people, because no private attorney would be subjected to that kind of harassment, and at least their clients would have attorney-client privilege, which also pertains here too, which also pertains to these client files as well. So we haven't gotten to the question of attorney-client privilege, which is which is covered by the files. Right. That's why the Coronado case doesn't go there. Now, it would be kind of ridiculous if the Police Officers Association in Coronado said, "We want to know what you wrote about us in your files," right? No, they'd be laughed at. And that's exactly what petitioner, outside of the HR question, are there any HR complaints about your employees as public servants pertaining to the things I had talked about, dishonesty, violence, abuse of authority. That's fair game, right? The rest of the material are materials in client files.
Okay. Thank you. I want to ask Mr. Andrews
Sure.
a question.
Wait, actually, may I have just one moment?
Sure.
My colleague is concerned about the chair's focus on the fact that there's a database and there isn't a database here. One of the facts in Coronado is that the database is composed of scanned client files in the Coronado case. So it is at its core, includes both scanned client files as well as public information. So that's what we want to make sure that's
Appreciate
clear.
that. And I'm familiar with that part in the case. All right, Mr. Andrews. So I think I'm compelled by the Coronado case with regards to this, especially the parts that cite, quote, although the California Supreme Court has not addressed the issue, it has recognized the principle that a public defender is not a state agent, but rather acts as a private attorney when representing clients, unquote. And other parts that says, in this capacity, the public defender maintains, this quote again, in this capacity, the public defender maintains the same level of professional independence as a private attorney, and the state is constitutionally obligated to respect this independence, unquote. Do you disagree with any of that?
I disagree with none of it.
Okay.
The Coronado decision is a good decision.
Okay.
I understand the committee's concern about the public defender's need to act in this private right to represent its clients. Okay, so 100%. But I'm still, so Coronado just, and I think you pretty much said it, it just doesn't apply here. I mean, it's great. We can talk about Coronado all we want, but it has nothing to do with our request for records. And how? Because Mr. Vu was just saying nobody would be crazy enough to ask for client files. Neither did we. We're not asking for client files.
Are you asking for information that might be in a client file or that are in known client files?
That's not, see, that's the problem, is that when you don't know what records exist and where they might be, you make a request. The other side then tells you, do they have the records, where those records are, and what they might contain, so you can decide whether or not, in fact, you are entitled to them. I can't answer your questions because I have no information from the Public Defender's Office. And if you believe their argument, it is that they should never have to produce anything because apparently the only thing they keep is client files, so that everything is connected with a client file. And no one should know better than a public defender, right? That simply stuffing something in a file doesn't make it privileged, any more than a criminal handing the gun to their attorney doesn't make that gun now privileged. It's still evidence. And wait, one thing I want to make clear, because this whole Coronado thing, this is not police officers trying to get information from a database, right, that affect the public defender's ability to do their job, and that police officers might have this sort of ulterior motive to want, right, as part of their job. I get it, right? Let's just address this, okay? This is Mr. Osley. This is Mr. Osley requesting records on behalf of himself. This is not Mr. Osley, the DA's office. This is not Mr. Osley, police association or association of anything. In fact, Mr. Osley is no longer a DA, okay? So let's even make it clear. Private citizen, okay? Not asking for client files, nothing having to do with his particular prosecution of any particular client case. It has to do with the fact that people from the Public Defender's Office filed a bar complaint against him.
A what complaint?
A bar complaint, right, alleging certain misconduct. And although some of it may have been related to client cases, we know for a fact that some is not, All right, so Iona Solomon, who's one individual in there, in her bar complaint makes accusations about specific personal, verbal, and physical threats by Mr. Osley against her, not having anything to do with the case. So that right there is responsive information that was never identified. Also, files, okay? We're talking like there's just a client file. There are emails, there are text messages, people communicate, all right? If public defenders are communicating about Mr. Osley, particularly with respect to a bar complaint filed against him individually, right? Now, this is important because when the public defender's office files a bar complaint, they are no longer acting as public defender. They are acting as prosecutor. They are the ones prosecuting, filing a claim against Mr. Osley.
Are you saying that it's outside of their activity as a public defender?
Absolutely.
Okay.
100%. And the Coronado's been twisted and turned because they're trying to use it as some sort of shield to prevent any access to whatever their public defenders may be doing or saying or writing down or emailing or text messaging. And I mean, it's only been made more clear by the fact when this all started, they said, we don't even have a process for responding to the Sunshine Ordinance. Then you say, well, what about personnel files? It doesn't sound like they even keep personnel files, which maybe they should if they have individual public defenders accusing outsiders of essentially harassment, physical, verbal, right? Wouldn't it be time to maybe have a policy addressing that? Maybe have something in that individual's file if that's truly what they're claiming against somebody else. So, you asked a very good question. I want to ask this whole in-camera review, two things. I understand on one hand, there's the concern that, hey, we don't have the ability to do that. Okay. On the other hand, what about this Coronado decision? Because, what did they do? All right. Well, number one, Coronado, they didn't ask for an in-camera review at the lower level, so that was their mistake. Two, when the court did look at what the basis would have been for an in-camera review, one, the dissent said, yes, we should have an in-camera review. Right? But even the decisive opinion said, well, the only reason we're not doing an in-camera review is because the reasons that the police officers want it aren't good enough, right? They said we want it because it's private information about us, because, what were some of the other ones? Let's see, it was private information, it was in their capacity, it wasn't in their capacity as public defender, and maybe something else, okay? Well, none of those situations apply here, right? Because Coronado said, well, police officers, it's not private because you're witnesses frequently in these cases, and this information is information that's relevant to those cases, and therefore, no, okay? Not the case here, right? First of all, prosecutors are not witnesses in the cases, almost ever as far as I know, but even if they were, the fact is it's not the same information being requested. And a database is like, that makes more sense. It's like an attorney work product, right? It's not something that just exists. Records kept in the ordinary course of business. They assembled this database for one specific reason. It was very easy to hone in on this and say, yeah, we could understand how this is related to their private function of representing clients.
Okay, let me
That is
ask you-
nothing to do with why we're here. And we've spent this our third session talking about Coronado.
Okay, I understand, and that's why we're here, because the task force itself was not clear on the applicability for items 3 or 4 through, was it 15? So I want to ask, for when you had made the request for those items, let's say for items 4 through 15, okay? Item 3 should have been easily releasable, and there could have been citations by the respondent saying that these are applicable or these are not applicable for disclosure. But for items 4 through 15, how did you come up with, besides item 4, how did you come up with the rest of that list?
Allegations of misconduct?
Yeah.
Just
the
in
people,
general?
the
Sure.
people. How did you come up, how did you find out, how did you know about those people?
Sure, because part of Mr. Osley's individual defense to the bar complaint is that the public defender engages in a pattern and practice of filing frivolous and baseless bar complaints as a mechanism of leverage, essentially, which is not the same, let me be very clear, because I don't want that to get confused, that is not the same as acting in their private capacity to represent and defend their client. Okay? And that is the problem. If I'm a member of the public.
You're making it more complicated than what I'm asking for.
No, well, I didn't think so, because these are people that he worked with who also had bar complaints filed against them, who they had heard threats from other public defenders of having filed. We also put down a couple of names in here because when they responded that they don't have anything, there were at least a couple of public defenders, I believe, that were in the list who said they were never even asked.
Let me ask you, so then your client worked with a person with the last name Nawabi. Is that correct?
Yes, I did a jury trial with them. It was the case.
I don't need to know detail. I just need a yes or no.
Okay.
Person last name Solomon.
Yes, if you want me to just.
I'm just trying to get a scope that I think was not clear during the main hearing for these particular items. And so the question I think I pick up on from Chair LaHood's question is whether this information would be part of an actual client that the public defender is representing versus whether they would be in a personnel file or in a communications file or some other administrative file other than client files that would, as Coronado is from what I gather and what's being, is being explained here, are part of information that's part of client cases that clients that they may be representing. So the question I have is, so let me do this. Let me ask Mr. Vu this question, if you don't mind.
Oh, yeah, sure.
Okay. So Mr. Vu, for items number 5 through 15, all those persons that are named, are they or were they clients of the public defender?
No.
Okay.
But
so,
can I clarify just really quick?
Yeah.
So items number 5, 6, 7, 8, and 9,
Yeah.
those items, the reason why, and since we were mentioning Mr. Osley, the reason why he knows them is because they are public defenders. Items number 10, 11, 12, 13, 14, and 15, again, the reason why he knows them is because they are public defenders. They're not DAs, they are not district attorneys. And so what is being asked of is basically public defenders, and the only reason he knows them is during the course of doing his job. Mm-hmm. So he's appeared against them in front of a court. He's appeared against them in front of court. They fought, they bickered, and now
So let me ask you, how is this different than the recent cases that has now, been made law that misconduct by police officers are disclosable? That has nothing to do with, investigative cases or anything like that. It could be even a misconduct in a lab.
Absolutely.
That kind of thing that I'm sure that you focus on quite a bit.
And I actually don't, and I don't disagree with that.
But how is it different than the information that we're not looking for the entire file, mm-hmm. but we're looking for a specific part of any kind of, not even a file, just any information alleging misconduct committed by if you're saying that these people named are public defenders, of a public defender. How is that part of a client file? It's not part of a client file. Because
a police officer represents the public, and the police officer's work is public in nature. The police officer, by definition, is a public agent.
Okay.
He is. There's a reason why they call them, peace officers, because they are actually public entities.
Okay.
At their core, they are public, to protect and serve the public. And also, I'm not saying that every single behavior by a public defender is exempted under Coronado. I think that's not the position that we're.
But how would the public, if the public wanted to know? I mean, even if they went to the bar and asked, do you have any alleged misconduct complaints about a public defender? I mean, wouldn't they be obliged to produce?
If the public went to the state bar to find complaints, they would find complaints the way that they would find complaints against any attorney, public or private.
Right.
And the complaints and the state bar does have a public way in which you can lodge complaints against attorneys, public and private.
Right. So isn't the information here about these particular attorneys that may be in custody of the public defender, aren't those disclosable? Isn't that information disclosable?
No, because those items occurred, the allegations occurred in the course of representing clients. And I think that's the.
But it's not part of the client file.
It is.
I have a question.
Yes.
So there was mention of a complaint with the Bar Association. Was that complaint made by an individual or on behalf of the individual by the Public Defender's Office? Did the Public Defender's Office participate in that complaint?
Mm-hmm. Let me one second. I don't. I'm not certain. Mm-hmm. I do know that the bar complaint was the impetus behind it was a public defender, and the complaint arose out of work representing a client. Now, the one thing that I definitely want to talk about a little bit about is the nature of whether or not is a bar complaint something that a private attorney would do versus what a public attorney would do, and I think that the leverage, which is what the petitioner had mentioned, is very much par and parcel with what any attorney would do in terms of defending their current and their future clients, which is that if you know a bad apple, right, you have a duty to pursue allegations against that bad apple, and if public defenders as public agents were forced to hand over their records in the course of doing that, you would put them at a disadvantage. And there's the and so, for instance, there are the investigatory files exception to the CPRA is one of the things that encourages complaints against license. Let me see here.
But that is specific to ongoing investigations by a law enforcement or other investigative agency against persons, and that investigative file, that you would then have to testify that the documents, so take the first, number 4, even just against Mr. Osley, all documents pertaining to any alleged misconduct by Thomas Osley. I mean, would you claim that to be an investigatory file?
We would what we would say is that all allegations of misconduct against Mr. Osley were not done against him as a private citizen. They were done against him as a party opponent in the course of representing private clients. In other words, the characterization that he is somehow a private individual making this claim is kind of stretching the truth a little bit.
But you didn't answer my question.
I apologize.
My question was in number 4, which is similar to all the others, all documents, the request was for all documents pertaining to any alleged misconduct by Thomas Osley. Would you declare that those, all or some or part of those documents are part of investigative files.
What I would say that they are part of the private function. No, I'm not even going to investigative files yet. I'm
But you
still,
just brought that up. It's part of protections under CPRA for certain information that is not disclosable.
well,
You brought that up.
I understand, but only if you were to decide that it's not a private file, it's not a part of the private function of the public defender's office. If you decide that it's actually in fact not private, that it's public, then the next step of the analysis is that are there other exceptions that would exempt that from disclosure?
Well, tell me with regards to any complaint about misconduct or other, what documents do you consider to be protected against any employee in the public defender's office?
Against any employee of the public defender's office?
Yeah. I mean, if I were to request information about sexual harassment, are there any sexual harassment complaints against, these 5 individuals that work for the public defender's office?
And we've stated that at the very beginning. That would be a public record, and if we had it, we would disclose it.
So how is that different than this?
Number 4, which is
Or number 5, or number 6, or number 7, or number 8, or number 9, or number 10, or under
we said
11?
that there was no public records.
So there were no public records.
There were no public records responsive to the request.
But the question, the petitioner is contending that there are records.
I don't think that there are no records. There are no records pertaining to that are not. There are no records of misconduct outside of representing our clients.
Okay.
So in other words,
Okay.
if there, in other words, there's nothing.
You're claiming that 4 through 15 is unresponsive. There's no responsive documents.
So documents may or may not exist, but they're not public, so they're...
Right, and the question then becomes, if they're not responsive because they're not public, that's one thing, because then you'd have to cite some law to say that they are not disclosable. But you're now saying that they are public, but that you don't have any documents that are responsive.
No. Actually, I'm not saying that those documents are there. I think.
That's what you just said.
Okay.
You just said that for items 4 through 15, that those would be documents pertaining to alleged misconduct against somebody, against an employee, would be public documents. You just said that.
No, let me clarify.
Okay.
So there are a series of, there are 2 types of requests essentially. Mm-hmm. There is a series of, one set are records of misconduct by the public defender's office, staff of of people who work in the office. Mm-hmm. That's numbers 5, 6, 7, 8, and 9.
Right.
That's series number 1. A second series are allegations of misconduct made by public defenders against the DA's office. Mm-hmm. Right? Okay. So there are 2 different series. So I want to clarify, of the 2 series, which ones are you talking about?
Which ones do you claim as being public, and which ones do you claim as not being public?
Okay. So with regards to the allegations of misconduct by members of the public defender's office, right? I think what the law says is that there are 2 areas. There is, as it pertains to the public defender's office, there are things that are public in nature. Things like, so for instance, violence, abuse of authority, unlawful discrimination, misappropriation of funds, what you would expect from, right, those things. Those things are public in nature. Mm-hmm. We do not claim that it's private. We're not claiming attorney-client privilege in those things. We simply don't have any of those records. They're not in the HR files. Now, the rest of the allegations outside of that are all things that occur in the course of 2 parties appearing before a judge saying, Your Honor, that person didn't misbehave.
Yeah, but we don't know that.
There,
We don't know what, we don't, all this is saying is all documents pertaining to alleged misconduct committed. So we don't know where they were committed. We don't know how they were committed or in what course of activity they were committed. That's not being specified. It wasn't
But that's
asked
not-
of the requester to provide documents pertaining to alleged misconduct committed by so-and-so during the course of a case. That's not what's being asked here.
but we did answer both sides of it.
So
because-
you
because-
answered
because-
the part that was during a case and the part that
Yes,
wasn't during the case.
Because what we said was that we had no public records exist.
Okay,
So we answered both parts.
okay,
of it.
let's stop there for a moment. Let me ask Mr. Andrus for items 4 through 9. Mr. Andrews. Okay, they're claiming that there are no responsive documents.
I mean, that's what they're claiming now. So, and I think part.
But isn't that what they were claiming before all along?
No, because the response we got, and you asked them, that's rewriting our request. We asked for any documents regarding alleged misconduct, period. Right? And all we got was a blanket objection to everything, say, well, it's either not a public record or it's privileged. You figure it out, and by the way, we're not going to give you any records for you to figure it out.
Do you know that any of these records exist?
Yes,
How do you know that?
because Mr. Osley was involved intimately.
Okay.
And know some of the emails that were sent and text messages, none of which have been identified or produced. And let me, before I forget, say something that I think may help a little bit. Going back to this whole in-camera review thing, you said, well, we can't. I don't read the Sunshine Ordinance to give the committee that little authority to do anything about a situation like this. I mean, when I was here for the first time, and I'll say this is my first time going through the Sunshine Ordinance process, right? And I remember sitting here, anonymous maybe, or someone else. I mean, there were thousands of documents and keys and all these things, and I'm thinking, all right, we're going to get one of these. And then I come up, and it's like, oh, public defender, and no, an exemption or attorney-client privilege. I don't know. You pick, and nothing. You get nothing because this is some special privilege that we have. And then I heard the committee's concern, and this is where I got really confused, and understandably so, because of Coronado, because they've turned this whole hearing and our request into something that it is not. Okay? We are not requesting the kind of things that were requested in Coronado. We are not trying to infringe upon the public defender's ability to represent its clients, period. Okay? They are not defending anyone. They are prosecuting Mr. Osley. Okay? Mr. Osley is not the DA involved in any particular case. He's an individual who is being accused of things that he needs to defend himself against, for which we sent out a typical public records request. This should not have been so complicated, and it has turned into a thesis or exposition on, hey, Sunshine Ordinance, public records. What is the public defender's role?
Okay.
Nothing. I mean, all very good questions, but we're not that important. We're not that. We're not trying to get to the Supreme Court. We're trying to defend an individual case, and this is something that any attorney should know to do, which is you can't just say no. Right? You've got to say no and why. And so you can do everything that they don't want to disclose. You can't do an in-camera review. Make them produce thousands of records, and they can redact the whole page except maybe Mr. Osley's name or something that's not client-related. If they would prefer it that way, because honestly, I thought it was more collegial to say, just give me a list.
Excuse me. They are claiming that they don't have any responsive documents alleging misconduct. Now, if you're claiming that there are documents that exist, I mean, I recall a case that was against the San Francisco Public Utilities Commission, where they were claiming that they don't have any records with regards to the purchase or the installation of something. The petitioners had made a CPRA request against Cal ISO, which is the grid operator. That were communications between the city and Cal ISO regarding those things. Okay? The PUC didn't have a leg to stand on because the petitioner brought evidence that there was communications, even though the PUC said we don't have any communications, okay? That's what's making this a little hard for us, okay? It's like he said, she said, okay? And that doesn't fly here, okay? This is quasi-judicial, okay? You got to treat it that way, okay? And I think it's important. And the importance of what the public defender does is essential. What the claims are, I wouldn't say the claim, what the decision out of Coronado with regards to the importance of the work and how the public defender is independent of government, where the prosecutor is the government, okay, as representing the people, okay, is an important distinction. Now, that is what we have to hold sacred. That is part and part, that is like core to our judicial system, okay? And the fact that the public defender is being paid by the taxpayers to provide private attorneys, services to people who can't afford it, okay? That's all that really the difference is, okay? I think we can all agree on that.
Yes.
Okay.
Yes. And to your point, I agree, and I'm sorry. And had I known that it was going to get to this point, I would bring in evidence and exhibits. But to your point also,
You're an attorney. Would you walk into court without some corroborating, something that corroborated?
because it's not our obligation. Absolutely. I don't walk in doing the other side's job for them. I don't walk in proving that they're not following the specific request. The statute says they're supposed to identify. I mean, that's why I laid it out in bullet point form.
And if they identify that they don't have any responsive records, as we hear all the time, okay? We don't have subpoena power. We don't have the ability to do in camera. We don't have any enforcement power. This is basically discovery in public forum, okay? That's basically what that's the way we're described,
right?
Okay? Now, orders of determination of meaning, because when you go into a court and you want to take this to the next level, the court will first say, is there a local process?
Yes.
Did you go through the local process? What was their response? And they take that with a lot of gravity, okay, based upon facts. We have legal counsel also advising us on how this works. It was not clear. It wasn't clear. What made it not clear in some part of this, Coronado may or may not have applied, but in other parts, in these particular items that the task force was unable to make a determination on, that's what we're trying to get at here. And so we're trying to get to a distinction between, now, on one hand, and I'm speaking in general to everybody, on the one hand, it's being told to us that the information around alleged misconduct was not in the course of, it's not part of a client file. It is on some outside of some bookends of the client file, okay? Which then puts it into the realm of being publicly disclosed, okay? Then we have an argument stating that the documents or information that pertains to alleged misconduct by this particular public defender was in the course of while they were in the middle of a case, okay? And that is what is, I think, a sticky point for us.
Okay.
Is trying to figure out then, is the conduct part of the client file because it was happening in the course of what was going on in court. If it wasn't happening in court and it was happening outside, like on social media or something like that, well, that'd be a completely different story. We need to know what that delineation is. So the PD's office is saying this was in the course of while the trial was happening, or the hearing, or some judicial procedure, and you're saying we don't know if it was or wasn't. We're just asking for documents, okay? And that's what we're trying to ascertain. Our job is to determine whether the information is public or not. That is it. That's where the beginning and end of it is for us. And if we determine that it's public and it should be disclosable, if there's some argument to say, no, it's not, it could be redacted or it's fully exempt from disclosure, then there has to be a citation of law of some point at that point.
Sure. Well, before I forget, let me do a couple of things. So first, in response to your point about it would help to have some evidence, right, a failure to disclose. Understood. Okay. The simplest one I think I can provide, and I can print it out here if it matters to you, although I believe the public defender just acknowledged it, would be the fact of the bar complaint that they filed against Mr. Osley. Okay? So there should be documents about the bar complaint they filed against Mr. Osley. There should be email communications
So
and text messages. I have the bar complaint.
Let's just take it one step at a time because number 4 is really independent of all the others. Okay? Mm-hmm. Number 4 is about Mr. Osley, who is here, who this is all about. The other people is for other reasons. Okay? Now we are not here to judge the intent of what a requester is asking. But we are, we do get concerned when respondents, the intent of them using certain laws to prevent disclosure. That is our job. Our job is not necessarily to judge the petitioner, but it's to determine whether there was a violation of the law with regards to disclosure, timeliness, or what have you, and then determine whether those reasons that are given are applicable or not.
Okay.
Simple, okay? So let me ask Mr. Vu. We're going to start with just number 4, because number 4 is very independent of everything else.
And 10 in conjunction. If you look at 10, because
Why 10?
she's the one who filed the complaint.
Well, we don't know that.
I do. It's on the document. And they can acknowledge it or not acknowledge it. I don't know.
It
But I'll
just says
print it
all
out and provide it to you if you'd
documents
like.
pertaining to any accusation. Doesn't say the accusation or accusation file number, or
No. 10. All documents pertaining to any accusation of misconduct committed by any employee of the San Francisco District Attorney's Office, i.e. Tom Osley, by Iona Solomon. I'm saying that's a complement to number 4. Number 4 says all documents pertaining to any alleged misconduct by Thomas Osley. Number 10 then narrows it.
4 is inherently a subset of 10.
I understand.
Yeah.
But I'm just
does
making
that
sure
make
because
11? Is
well,
11 a subset? 12 a subset? I mean, I guess 10 through 15. You're
No.
Oh, no.
well,
Yeah, well, they could be. My only point was because you were asking for evidence. I mentioned the bar complaint.
okay.
It was filed by Iona Solomon,
okay.
and so there's
You're
something that should have
naming
been
the
produced.
You're naming the actual accuser.
Yes.
Okay, got it. Okay, got it. Okay, so Mr. Vu, let me ask you with regards to number 4. Since
Yes.
that is about the actual person who the complaint was made about to the Bar Association, okay, does the Public Defender's Office have any information with regards to that? That has nothing to do with being in a case
It was,
or activity of a case.
sure. What we're talking about is that the accusations came about in the course of representing clients. The bar complaint was filed in the course of protecting future clients from misbehavior from opposition counsel. So that's all within, if you look at the wording of Coronado, which is that, is it a traditional function of defense counsel? So that means that if you had an attorney, if you were paying for an attorney, would you want that attorney to be aggressive against their opponent and collect data? And if you find that opponent to be misbehaving, would you want your private attorney to file a bar complaint?
Yeah, but that's not in our jurisdiction.
But actually, it is in your jurisdiction because what the Coronado Court said is that if it is within a traditional function of a defense counsel, then it is by definition private. It is in the interest of representing private clients, and therefore it is not disclosable.
So you're saying the filing of misconduct to the Bar Association is in the course of the regular...
Absolutely, because wouldn't you want your defense attorney, if you were paying them good money?
But is that part and parcel to a client file?
It doesn't have to be part and parcel of the client file, because in Coronado, there was public information that was being gathered from multiple sources that were being assembled, and the court said that that act of gathering information was a private function, a traditional function of defense counsel, what you would expect from an attorney if you were paying for that attorney. And because that's what you would expect from a paying attorney, the public defender gets, their clients get that right too. That's what the Coronado Court is trying to protect, is the interests of poor people, that their attorneys have just the same rights and abilities as a paying attorney. So the question really is that if you are hiring a private attorney and that attorney knew that their opponent was misconduct in court, and that one of the ways to leverage that is to file a bar complaint, if you expect your attorney to do that, then you should expect the public defender's office to do that as part of their private function as well.
I get that. But again, Coronado is very specific about disclosure of what's in an individual's file.
Actually, Coronado pertains to not just items in the individual files. The Coronado case, within the fact itself, had items that were public.
Okay, so here, while the court's statements in Kite, which was another case that they were, Kite versus Duggar, 1990, appear in the context of representation of a single client and address disclosure of that individual's file, the fact some of the information in the database may not be attached to the particular client file is not dispositive, because it does not change the nature of the information into that relating to the public's business.
That's exactly the same. That was exactly the quote that I was looking for, Chair Wolf, which is that what the court in Coronado said, that just because it's not in the client's file doesn't make it public. It could be.
So then the question is, at this point, see, this becomes a point where I'm not clear. I can't speak for Member LaHood, Chair LaHood, or any other members of the task force. I can't tell or know whether that information about reporting of misconduct is part of or pertaining to a particular client file, whether it's attached to the file or not.
I can tell you one thing, is that our office does not make complaints that do not start from client files. We do not know, so we do not make complaints. Our only complaints come from conduct that we observe in the course of representing individual clients. We file those complaints because we feel it is our duty as a traditional function of defense counsel to put that attorney on notice to protect our future clients against future behavior. So the part of the complaints, the allegation of misconduct of Mr. Osley, those were all done against opposing counsel. They were not done against a private citizen. And as a point of record, Mr. Osley filed this CPRA while he was still employed at the district attorney's office. So really, this is about a party opponent who is unhappy with the performance of his opposing counsel and wants to use the CPRA as a way of getting back at opposing counsel doing their job.
We're not interested in the intent. Okay, so we're interested in determining whether the information that's being requested is public or not. Through this, here it's going to be through the CPRA.
You're right. I mean, I shouldn't have done the second part, but I think the first part are two facts. I think are just simply statements of fact, which is that Mr. Osley filed this while he was still at district attorney's office, and that Mr. Osley was not. This is not allegations of misconduct against a private citizen. All of the allegations of misconduct that I know of that are in my office pertain to the performance of an opposing counsel.
Okay.
That's what this is about.
I'm okay. I don't want to take. We're running a little longer than I expected. I feel like I'm going around in circles. Okay, and part of that is because I'm not an attorney. Okay, so I can only go by. We're here to do the people's business for the purposes of what's in the public's best interest for disclosure, okay? And I think, there's kind of a core point here. And then to determine whether the information around the activity of filing a complaint of misconduct is within the course of the business in representing a client or not, whether it's attached to the file or not, okay, in that part. I am not confident personally to be able to make a decision about that. I need more education, and so I'm going to suggest that we can continue this so we can consult with our legal counsel to provide us with proper advice, and based upon all the evidence that's given. If he was here, we could ask for it here, and he probably would say, I'd have to research that a little bit more, okay? Because I think sitting on Coronado alone, while it's compelling, it doesn't explain this part about the reporting of official misconduct as whether that is in the regular due course of the business of as part of the client file, attached or not, or whether is you observe 50 times that they've done it, okay, then you're claiming for all those files that it's in the course of business for all those files. If you're just sitting in the back of the courtroom and you're a public defender and you observe it and then you file a complaint with the bar because you observed a misconduct, lawyer to lawyer, we don't know where or how this was happening. That's why it's kind of like we would want to know whether if the why the concept of seeing things in camera was so that we can determine that the complaint of misconduct that was filed was during the course of that when that client file was open. Okay, I think it's fair. For fair to the Sunshine Ordinance and to the CPRA, and to the people that rely on that to pursue this a little bit further on our behalf, and for both parties, so that you come out with the right answer. Okay, because what happens here does have a little bit of gravity. Okay, it may not hold as much gravity as case law, but it has some gravity, and we take it very seriously. Or else I wouldn't be spending my volunteer time every year in and out to do this. So I would appreciate a little more patience with us to allow us to do more due diligence, because it's important. You're talking about a level of jurisprudence that we don't have experience of, and I think we need to be educated. I think I need to be a little more educated so I can understand. I can manage the complexity. I don't know enough about what is and what isn't. A judge would. I'm not a judge. Okay, so I don't pretend to be either.
I have one other question.
Oh no!
I know.
Chair Wolf was just wrapping up for us.
I know. I can be very concise.
But Chair Hood, I just want to say before you ask your question, may I just? I want to say that thank you, and we're more than happy to come back as many times as necessary to sort of we're more happy to come back as many times as necessary to help. It's an interesting question, and so it's not a problem. But yes, thank you.
One of the things that I'm a little confused about is you talk about doing this on behalf of future clients. So if it's on behalf of future clients, there cannot be attorney-client privilege because the client doesn't exist. If a private attorney were to be doing something like this on behalf of future clients, again, there would be no attorney-client privilege. They were just doing this because they thought, I want to do this for a particular attorney, or because I see behavior that I want to report. So in both cases, not protected by attorney-client privilege.
No, it's not.
Right.
Yes.
However, on the public defender side, the difference is that your activities that are not attorney-client privilege, I believe, are subject to the Sunshine Ordinance, whereas a private attorney would not be subject to the Sunshine Ordinance. However, and it seems to me that adds a layer of complexity here. Am I?
I agree. I mean, I think now I haven't gone to the charter in where the public defender was created as to, what is and what is applicable to Sunshine in that particular department. Okay, I mean, just like this body is it acts somewhat as oversight for all branches. Okay, it's meant to be that kind of way, in the way a court would have oversight over the executive and legislative branch in that kind of way in all departments. So it's hard for me to know specifically for the public defender about which parts of it would be applicable under Sunshine or not. I have not really, and that probably would have been a good point of research I could have done prior to coming here today, just thinking about that in hindsight. So that's why I'm interested in continuing
Okay.
for the sake of time and also for the sake of just getting down to these 2 points.
Okay.
Okay, so I'll move to continue.
I'll second the motion.
And I would just add that, this would be upon advice of legal counsel by this committee.
Right.
This committee.
Agreed.
And then we'll reschedule accordingly. Now, let me just ask.
And
if
thank
there's-
you all for being here. I know this is
Yeah,
taking a long time.
Yeah, but I do also, if there's some sort of timeline that people are working on that would also be we can try to work in that realm too. Mr. Andrews, did you have something? you wanted to say?
Thank you. No specific timeline. We're agreeable. I want it for clarification. As part of any continuance, can I assume then, I know with each hearing we get a notice of you can submit additional documentation before the hearing. So to address your concerns and questions, we can provide additional documents,
That would be helpful.
authority regarding this whole point about whether, filing bar complaints is somehow part of their public responsibility. Happy to do that. And even if, I know my client just wanted me to offer, to the extent you wanted evidence, he's willing to swear under oath and provide it.
We're not allowed to do that.
I understand, but I wanted to make the
But,
offer nevertheless. And then
I
there
agree.
was one point, just again, it's mainly just something, while top of mind, I want to say for your consideration before we leave and come back, right? The public records thing. So when the public defender files motions and when they're saying all of this stuff is part of their job, right? In court, even case related, because there was all this confusion about, well, does it matter if it's in a case file or out of a case file? Okay, when they're filing motions with the court on behalf of their clients in a case, right, and they're alleging misconduct by any DA and they're attaching emails and messages, any privilege has been waived. They've put it in the public record. All of that exists. And again, why I didn't think I was going to be requested to pull every case and every exhibit they ever filed, but those are documents which could have and should have been produced. That's just a fact. I don't know that there's anything to debate about it. By virtue of the fact they filed it in court, it's a public record. We don't even have to debate, attorney-client, privileged, Coronado. The fact they gave us nothing is really the problem here. And not only nothing, but nothing to go on to decide if that was appropriate. Because if it comes out any other way, if we don't have the ability to get something, then there's no point in ever asking the public defender for anything.
But why-
Because they'll just say it's tied, because all we do is defend people, and somehow it's connected to defending people. Coronado. Right? That's all I've heard in 3 hearings, and I appreciate the intricacies, but it shouldn't be that complicated.
Let me just for the sake of asking, why wouldn't you bring this to court and have a judge, have a real court order or decision, have the process of a writ,
To your point, we intend to. But, and to your point earlier about the gravity, and the court does bear, in mind, was there a local ordinance? Could you have gone through it? That's why we start with Public Records Act request. Then we do the petition. We also, if you saw in our papers, we didn't just sit and wait. When they didn't provide anything, we wrote to the city attorney, right, your counsel, and said, hey, what's going on here? And their response was, not only brief, but also non-responsive. It didn't look how many hearings, and they just
Well, wait a
basically
minute.
said,
Are you saying that you contacted our legal counsel or the city attorney?
no, the city attorney. I'm saying,
Our legal counsel
yes,
is
separate,
different.
but I mean, we also went to the city attorney
Okay.
in addition and before going to court,
Got it.
right? Because the idea is we don't want to start, we have to file a case, and now we have additional fees, which, again, a private citizen, as Mr. Osley is, should not have to be forced to bear, because we have a sunshine ordinance so that the public can have access without having to hire a private lawyer and spend money unnecessarily for documents that we all know exist and could have and should have been produced. So but we're happy to brief it and be back here as many times as the committee sees fit.
Okay, are we going to bring back to this committee or back to?
No, back
Hold
to
on, hold
this
on.
committee.
Right, so we had a motion, we had a second.
Right, now we need
Public
public
comment.
comment. Okay, but we allowed the parties to
Right.
have the last say. Is there any any public comment?
Okay,
Just thanks for your time. I've worked also at the Public Defender's Office, and I really appreciate it. I didn't know you volunteered. Thank you.
thank you. Seeing no additional public comment, please call the vote.
Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion passes.
Thank you, everyone. Let's move on to the next item, please.
Okay. Item number 7, file number 19080, complaint filed by Paul A. Vanderwart against the Department of Homelessness and Supportive Housing for allegedly violating Administrative Code Section 6725 for failing to respond to an immediate disclosure request in a timely manner.
Are the parties here? Okay. If we could have the petitioner come up. I don't know if you heard when I said earlier, we're here today to determine jurisdiction.
Very good.
It won't be a full hearing.
Very good.
You've got 5 minutes.
Oh, 5 minutes. I want to thank the committee for its indulgence. This arose in July, and I've been having some discussions with the representative of the department here in the hope that we could perhaps reach an agreement about this. I think I'll let her speak to this. Her position is that they've made a reasonable search, don't have documents responsive to the request. My position is they had better, and hopefully through an interactive process we can determine we can reach a better understanding. The documents that my name is Paul Vanderwood. I was a planning and development consultant in San Francisco for 23 years. Worked with many of the agencies or the city's homeless service agencies, and I have a very strong interest in the design, implementation, evaluation of the city's homeless services. That's been strengthened since I was determined to be disabled in 2015 and was handed an SRO apartment at the Mentone. The issues that are at stake in this document request are the most critical issues that address the city's implementation of permanent supportive housing. I've requested of the department documentation of its compliance with state law. I believe it's Welfare and Institutions Code. It's cited here in the request. Let me actually pull that up so I can give you the exact reference. Requiring the department to implement the core components of Housing First. It's not done that. Or there's no evidence that it's done that. The second issue that I requested was information relating to any review the department had done, what's required for this compliance. I mean, this is Welfare and Institutions Code 8256B, which provided a 2-year period within which public agencies in California could bring their Housing First programs in compliance with state law and implement actually an evidence-based intervention, which the department has not done. I asked for information regarding an evaluation of Care Not Cash. There were numerous articles published in the San Francisco Chronicle trumpeting in 2016 and 17 the department was doing this. The department has not produced any documents. And then finally, I asked for any review the department has done of an investigation of what is essentially a contract fraud that's been going on for 15 years by the Care Not Cash contractors. Every year, the Care Not Cash contractors report through the director first of the Human Service Agency and now the director of HHS, Mr. Kaczynski. They report that they have a 93 to 96% housing stability rate. This is completely fraudulent. The day before Mr. Kaczynski took office, the Budget and Legislative Analyst issued a report on May 31st, 2016, which found, based upon a large independent data set, that the true housing stability performance is 34% over 18 months. This is the worst performance in hundreds of jurisdictions in the world that's implemented Housing First. The reporting is fraudulent because the data that's being reported to the Board of Supervisors, and then by being included in our grant reports to HUD, as being reported to the federal government, the fraud is continuing there. These programs would have been recognized for the failures they were, a dozen, 15 years ago, had the true facts been known how bad the performance is. But because they have used data reported by the contractors concerning whether tenants left in good standing or not, well, which is something has nothing to do with housing stability at all. You can leave in good standing, not owing the providers any money, and go sleep on the corner, and you're counted as being housed. So this is a quite deliberate fraud. It's been going on for a very long time, and very unfortunately, it's continued under Mr. Kaczynski. It involves hundreds of millions of dollars. It involves the core integrity of our city's homeless programs. I've spent 4.5 years working. I've reviewed more than 15,000 studies. I'm an expert in evidence-based design, intervention, and evaluation. For example, I designed Larkin Street Youth Center's continuum of services. I'm very concerned that HHS get this right. I'm also very pleased that Abigail, representing the department, and I have been able to have some discussions about some of the things the department may do. And I think we're hoping that you might grant us a continuance so that we can continue these discussions and come back with the matter resolved through an interactive process. Thank you so much for your courtesy.
Thank you.
Good evening. Thank you for.
1 second.
Oh,
okay, go ahead.
Okay, thanks. Thank you for being here, always for your time. And thank you to Mr. Vanderwalt for talking in advance. I always find it's helpful to meet face to face and kind of pull through some of what some confusions may be. I want to make sure we're speaking specifically to the sunshine aspects of this matter, and then also look forward to continued conversation with Mr. Vanderwalt about the larger issues that he's raising, which, of course, the department is very interested in absolutely doing the best work that we possibly can on behalf of the clients that we serve, and our strategy actually articulates the implementation of all of these best practices that he's talking about. So I think we're actually quite aligned on the things that he's saying. But specifically to what you all, what brings us here this evening, we did receive a public information request that was labeled as an immediate disclosure request from Mr. Vanderwalt. It was not deemed to be an immediate disclosure request by the department because it wasn't simple or routine, and we needed to check with other departments. I just want to note that's often the case for us because we're new. We just always want to make sure that we have the whole story, and part of the story doesn't exist with another department that existed before we did, if that makes sense. So we conducted that search, and based on each of the items, we provided the responsive documents available in a timely manner. And so from a sunshine perspective, I would posit that we responded in a timely and complete manner. The larger questions that he's raising are certainly and critically important to us. What I would like to do is, since some time has passed, I would like to go back and do another search, because it could be that we have created or now have further documentation that would be responsive to these requests. So I want to just do that double check. And I also want to make sure that we're continuing the conversation with Mr. Vanderwalt. But from a sunshine perspective, my point of view is that we responded in a timely and complete manner. And I'm happy to answer any questions about that, of course, as you have them.
Thank you. You can stop the clock. Yeah. Okay. Well, so there seems to be it seems that both parties would like to continue this for more time. Would that be an appropriate next step, and then have them come back to this committee we don't necessarily need to head to the full task force?
Right, because this is for jurisdiction. So it begins and it would end here.
Right.
So yeah, they would come back here.
Okay.
So I'll move to continue.
I'll second the motion.
But let's put a bit of a timeline on this.
Just hang on for 1 second. So I don't actually think there's a Sunshine Task Force complaint here. I think because I believe that we responded in a timely and complete manner. But so that's just the nuance that I would add. But I am very happy to have met with him and would like to continue the conversation.
Well, then let's just qualify this for a second, Mr. Vander Wert.
May I respond to that?
Sure.
I think there is most certainly is a Sunshine Task Force issue here. I accept that they made some kind of search. I don't think it was adequate, but I would like to work with her through an interactive process. Mr. Kozycki, I wrote directly to Mr. Kozycki because of the compelling importance of these issues. And there was no response from him for several weeks. I wrote to him and said, I will file a complaint. And then I did file a complaint. Eventually, so July 6th was when my initial request was in as an immediate disclosure request. I have no concern as to whether we look at the 2 to 48-hour period. Certainly, there was no attempt to produce anything within 10 days. The department has not produced responsive documents in any of these categories. Once again, I hope we can reach a better understanding of this. I do think there is a Sunshine Act issue. Mr. Kozycki is a director of the department. He has a fiduciary duty to the city, and he has a duty to comply with the Sunshine Act. When I send him a text, an email saying, could you please forward to the appropriate member of your department this request for documents on these issues, it takes him 60 seconds to do that. Instead, I just got stonewalled. And so, once again, I welcome the opportunity to work with the department on this, but I would want to leave open, the issue of whether there is a Sunshine Act issue.
Mr. Vander Wert, let me ask you this. When you made an immediate disclosure request.
Yes.
It's an enhancement of the California Public Records Act.
Yes, sir.
The requirement is that a response, not necessarily of documents, but just a response of receipt, be made by the end of the following business day. Did you get that?
No, sir. I got no response at all.
Okay.
When
did you get a response? And we'll hear. I'll ask for your response.
I actually understand the issue now. Thank you.
Okay.
So I wrote again to Mr. Kozycki on the 26th, got no response. Then there was a letter. I don't have the exact, and I apologize. We will get you a full packet here before the next hearing. There was a letter saying we're working on it. It'll be within the week. Then several weeks later, on August 21st.
Well, wait a minute. Let's not get ahead of ourselves. Did you receive a response requesting additional time?
No.
Okay. Thank you. Continue.
I did receive a response on August 21st, which I deem to be non-responsive, and I will work with the department to see if we can get a meeting of the minds upon this. Because really, I'm here to protect Mr. Kozycki's reputation, and I'm here to help the department. I don't wish to, I'm not trying to embarrass anyone, but I believe these policy issues really need to be addressed, and they fall within his duty to address. On the 21st of August, then, the department responded. They provided a link to their strategic framework, which, of course, I'm very familiar with. And they also provided me with 14 contracts, 4 of them for ECSSF. I already had those. They provided them previously. And then 10 for other organizations. I'm not quite sure why that was regarded as being responsive. They were interesting to read, but they didn't respond to my concerns. So I hope that's sufficient. I do appreciate Ms. Ledger had been very clear with me when I was granted my request for a second continuance that I should not come back asking for a third. I appreciate very much your willingness to indulge us. I do think there are important public policy issues that we can make some progress on. Thank you so much.
Okay. I have a thought. I wonder if we should modify this and there doesn't seem to be any. It seems. I think we should modify this and make a motion for jurisdiction
Okay.
And are you suggesting that we should push it all the way through, or that
I would
we
suggest that we push it all the way through based upon those two claims. And then as far as the responsive documents part, we can then
determine whether it's been
communicate
fulfilled.
that to the task force,
Right.
that's what's happening.
Right.
And then, we can then say, we can adjudicate on whatever the task force feels like it needs to adjudicate, but then the responsive documents will be coming later. It probably get referred back to this committee for monitoring.
But we would
kind of thing.
encourage you to keep working
Yes.
together, because that will make things move much
Right.
faster.
'Cause in the end, it's about what you were asking for.
Okay, so can I rescind my initial
Yes,
motion?
you can.
I'd like to make a new motion to find jurisdiction and to move this along to the full task force.
And that the records are public.
And that the records are public, and I would encourage both parties to submit any documents that you want us to consider,
Right.
want to be considered by the full task force.
And just for the sake of disclosure, any reasons why certain documents should not be disclosed with a reason, based upon our previous case. I think it's really important for respondents, especially folks who don't come here that often, to make sure that you are working on as ironclad as possible reasons why information should not be disclosed.
To the best of my knowledge, they're not claiming that they're documents. They're claiming they don't have documents.
You guys figure it
we'll
out.
We'll figure it
but
out.
They can come back and say, well, these documents, are this, that, the other thing, and under this section of law, whatever exists that they feel is applicable, will then determine whether it is or not.
And again, if there's any redaction, just make sure there's justification for the
Right.
specific redactions.
That's what I'm talking about.
Yeah.
And then when do we come back?
I was going to say, should they come back in April to the task force?
Sure. Yeah, I don't think this will take that long.
Okay.
Sure. Let's do it.
Thank you so much for working so late tonight.
We have to vote.
Oh, sorry.
Is there any
So
public
wait a
comment?
minute. No,
Oops.
hold on.
Yeah.
We want to give her some time, too.
Thank you, and I appreciate, Mr. Vanderwalt, again, you clarifying. So I thought we were talking about a sunshine concern around responsive documents. We did conduct that search and provided the responsive documents that turned up in that reasonable search, and I am happy to go back and look again. And I appreciate you drawing, again, to the attention you have in your memo what happened from the department's perspective in terms of the IDR directed to Mr. Kazitsky, and we know that he has a responsibility to respond. And we have added, just as an additional hope and help for this, because he receives so many emails and doesn't respond to them on a daily basis. So an IDR directed to his box is a complicated thing. We have added, which I hope would be helpful in a future situation, an automatic reply that says, please do direct this to the HSH Sunshine box so that we can be as responsive as possible if it's a public records request. I am also aware of his responsibility. He is aware of his responsibility as a department head, and that automatic reply doesn't.
It's actually it's not applicable.
But we're trying to be as helpful as possible to people requesting
I
documents.
understand. Just know that the difference between the Sunshine Ordinance and the CPRA requires agencies, departments to respond. The Sunshine Ordinance is an enhancement of that for custodians, actual people that have those documents in their hand.
Mm-hmm.
So whether you want to direct them to the Sunshine, email address or not is of no consequence. There's no requirement for that. The custodian is the one that's being contacted directly. It's their responsibility. And as you're pointing out, him being a department has extra responsibility as cited in the ordinance itself. He has a higher level of responsibility. In fact, he has some liability to it.
Absolutely. We are aware of that, and I'm just wanting Mr. Vanderwalt to know that his request did sort of prompt us to create an additional hope that that you wouldn't have gotten a no response. You would have gotten something because I think Mr. Vanderwalt in this case would have been very willing to direct a request to the Sunshine Box, and then he would have gotten a faster response.
May I?
Yeah.
I can confirm, Mr. Kaczynski, she is correct, that this has been added. It's very helpful. I wrote to Mr. Kaczynski as a courtesy as the director of the department. I'm happy to send the request wherever it's going to get responded to. I think Mr. Kaczynski needs to know about this and respond to it. However they want to handle it is fine. I thank you so much, very much, for your clarification. That's my reading of the Sunshine Act as well. I appreciate your exposition of it. Thank you. And thank you so much.
Okay, thank you. Is there any additional public comment? Seeing none, please call the vote.
Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to find jurisdiction and refer to the task force passes. And I will do what I can to schedule this matter in the early April agenda before the task force.
Okay, great. Thank you.
Thank you, everyone.
Thank you very much.
Thank you so very much.
Thank you.
And it would be 5 days before that date to get materials.
Yeah, I'll send you a notice of hearing, and then you'll get the information that you need in that.
Thank you so very much.
Okay.
Thank you. Next item, please.
Item number 8, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
So I just wanted to go back to the Andrews versus public defender case for a second. So we want to just make sure we get our questions that we are going
By our
to
counsel.
by our counsel.
Yeah.
So one would be: are these records public? Items 4 through 15. Okay.
Oh, hang on. I made a note of it. Oops. I think hold on. I put a note that's at 255, but.
I mean, it's in the memorandum. I mean,
Yeah.
it's repeated so many times. Yeah.
Yeah.
And it would be 4 through 15, and 4 through 9 should be taken independently of 10 through 15. The second question I have is: what activities of the public defender are considered public? And what records, right? What activities and records?
Yeah, and can we ask specifically if conversation or email and text discussion and other documents generated around a bar association complaint
that are not part of that are not specifically part of a record, attached or unattached, of a client file?
Right, that are not part of a client. Right, that are not part of a client file. Would those be considered public record?
So random.
Right, conversation or random communication about a bar association complaint, not attached to a client file. Which raises the question: if you attach something to a client file inappropriately, does that give you an umbrella?
Let's be clear. Like, if you want to use an example, if you go back to Coronado, it says here, while the court statements in this other case, Kite, appear in the context of representation of a single client, address disclosure of that individual file, the fact that some of the information in the database may not be attached to a particular client file is not dispositive. So if there is other information that pertains to the client, but it's not part of the client's file,
right,
that's what it means to be unattached.
Right, okay.
Okay? So it's either attached or unattached to a specific client file.
Right.
Okay, versus random discussion that has no pertinence to any particular client file.
Right, which seems to be some of the direction that some of the conversation was going.
Right. Now, the argument that the public defender puts up is that we wouldn't even make a reporting of misconduct unless it was involving a client.
Right.
Okay. So, the question is it based upon observation, in the course of a public proceeding, versus what's part of a client's file that may be protected under attorney-client privilege, that the attorney is bound by.
Right.
Not the client. The attorney's bound by attorney-client privilege. So, do you follow that? Okay.
Well, and then again, the conversation about protecting future clients. There is no attorney-client privilege for clients who do not yet exist.
Right, but I think what they're talking about is their
special role.
Their special role.
Yeah.
And that is part and parcel to the work that they do, so that particular activity would be protected. Now, the question is does a court think that?
Right. Does a court think
Does
that
the bar
filing
think
a complaint
that?
with the Bar Association?
Do they think that filing complaints against each other, one or another, is considered part and parcel of a client's file, or that kind of thing? So I think that those kind of questions are important. So the two areas that we're focusing on here is one is whether the information, the claims of or allegations of misconduct are attached or unattached to any one or another client file specifically, versus random conversation or discussion or communications about misconduct.
Yeah.
And that first we need to understand the distinction, and then second, which is public and which isn't.
Right.
Or are both public or are both not public?
Right.
We need to figure out what that.
This is This is a very complicated one.
It is.
Yeah.
It is, and I would definitely err on the side of caution for this.
Right, and taking the time that we need to, and not making fast judgment.
Right.
Yeah.
And the last. Yes.
Yeah.
No, this goes to legal counsel, and who's going to give us advice.
Yeah, and
Yes.
because this is so complicated, and I don't want to, just holding it in my mind, I think having it in consecutive meetings is helpful. So if we can put this on the next one as well.
That's fine.
If he can, that would be.
But the advice he gives us is protected under attorney-client privilege. That's why it can't. If he's here and we start talking about it, then it's one thing. It's up to us to make it public, but which most times we do, because once we get the answers,
because we like transparency.
Right. But the other thing is whatever information that we discuss in that realm, if it helps us make a decision that's specific to this versus information that's in that attorney-client privilege, in that legal advice that's protected, are talking about other cases and things like that. Part of what we try to do also is we try to make things as general as possible, and if we're going to be talking about specific cases that are either still being heard or those things need to be protected. So that's why we're doing it this way.
You want them to answer, number one, whether the allegations of misconduct attached or unattached to any client file versus random conversation, discussion, or communications about misconduct, or are both public or not public.
It's not or. It's comma. Are they public, or which ones are public?
Right.
Which ones are public?
Which ones would be considered public documents, even if they're even if they need to be redacted for whatever reason?
Right. Yeah, I guess the best word to use is disclosable.
Yeah.
Disclosable versus exempt.
Right.
Okay. If they're exempt, then they can get completely withheld.
Right.
If they're disclosable, they can be redacted. And then there's a final question, which is the production of cases that are already closed that the public defender did not produce.
Another thing comes to mind with the things that happened in, you know what, it gets way too in the weeds. If it, you know, was in public, then shouldn't they already have access
Right.
to the transcripts from those
Right.
cases?
Okay, that's all I got. Okay. Right.
That would be
And
great.
then he'll make an appointment. Well, it's just so full of jurisprudence that, you'd have to, even if you went to law school, you probably would need years of experience to figure it out. Maybe not, but it's beyond me.
All right, so I've got the questions, and then the third question is the production of cases that are closed that the public defender did not produce.
Yeah, whether that is appropriate or not. This is going to be legal advice from a legal counsel, be protected by attorney-client privilege to advise the task force on and educate task force. And the task force this committee and/or task force can break the attorney-client privilege and make it public at any time.
Last item?
That's all I have.
That's it? Yep.
Item?
Ask for public comment.
Oh, public comment? Seeing no public? No public comment?
I move to adjourn.
I move to adjourn.
Is the clock there, I don't think it's correct.
I have 7:07.
I have 7:03 on my,
That's 7:08.
7:08, all right, we'll say 7:08.